Hello to all. Welcome to the webinar today. I'm Cindy Potter. I'm Secretary of the FSBPT Board of Directors, and I want to welcome you all to today's Regulatory Hour Judgment. Our speaker today is Dale Atkinson, and he'll lead our discussion about recent judicial judgments addressing professional regulation. If you've been part of the webinars over the past year, you certainly know who Dale is. Dale has received his law degree from Northwestern School of Law in Portland, Oregon, and he's the sole managing member of the Northbrook, Illinois law firm of Atkinson and Atkinson, LLC. His firm represents various associations of regulatory boards, and he represents many different professional associations. He is a frequent speaker before all of these association clients, as well as other regulatory groups, and publishes widely on regulatory subjects. Before we get started, as a reminder, we have two great opportunities for members coming up. From February 11th to the 13th, we will hold a virtual regulatory workshop. Dale will share more insights, and you'll get a chance to hear from FSBPT staff on important initiatives and issues. All board members and board staff are eligible to participate at no cost. And then in May, we will hold an in-person board member and administrator training in Alexandria, Virginia. We are really excited to gather together again. Spots are filling up quickly, so be sure to express your interest in attending by February 20th. And the chat, in the chat will be the link to provide more information about this. And now I'm pleased to turn the program over to Dale for what promises to be an informative, thought-provoking, and entertaining session.
Thank you, Cindy, and welcome everybody to the year 2022 as we launch the next round, if you will, of regulatory hours. So I'm pleased that you're here, and I am pleased to be here and provide you hopefully with some content that you think is relevant to your world. We are calling this January Judgment, and I've selected a couple of cases to talk about, both from the same jurisdiction, one from 1982, and then one again from 2021, that identify related, if you will, issues and are addressing a statute that over the course of years has changed just a wee bit, but it's basically the same statute from 1982 to 2021. So a little bit about where we're going. I'll apologize up front now. I'm getting over something, and so if I cough a few times, I truly apologize, but I'll do the best I can to fight my way through this. As I cover these cases, I'm going to try to bring up issues that I think are relevant and important, and I encourage you all to participate. So use the chat, unmute, speak your mind. So if I say something that you have a question about, feel free to ask that. If I say something that's that you don't agree with, obviously feel free to chime in and help guide some of these discussions. And so, without further ado, let's keep moving ahead here. And let me start out, as I always do, with all sincerity, and that is to say thank you. Thank you to the FSBPT Board of Directors for continuing to have these webinars and allowing me to be involved. Thank you to the staff for what they do to put it all together. Great job, and they make it easier for me technologically. So a big shout out, thank you to the entire staff. The biggest thanks goes to each and every one of you on the line today. Whether you're an administrator, executive director, a volunteer board member, an assistant AG, an inspector, anyone who is involved in the regulatory process, you deserve a big hearty thank you. You're not thanked enough. You all have heard me say this before probably, but I will reach out and give a big sincere thank you. The role that you play in protecting the public through the enforcement of the Practice Acts is absolutely critical, and it's been subject to increased scrutiny of late, scrutiny that I believe we should all welcome. But at the same time, a big thank you should go out to each and every one of you. Now, as is tradition, please to make sure, one, to make sure you know how to use the chat, and two is to make sure you're listening. In your imagination, where are you right now? Are you a 1? Are you a 2? Maybe some of you are glutton for punishments. You're 3s. I see a 3 already popping up. And of course, it's always fair game to talk about hockey. So if anybody wants to be a 4, that's no problem. Hockey comes out usually in every one of my sessions. And so I added that picture there. So welcome, and let's bring our thoughts into the regulatory community excuse me, even if you're sitting on top of a mountain somewhere. And we will carry on. Excuse me, as is also tradition, I usually put out a picture of a famous either real or fictitious lawyer up there, but this year I decided to, I guess, just at least to start out 2022, put a picture of myself up there. Good looking, strapping young man there. Don't be fooled by my 1970s hairdo I have now, as opposed to the short hair there. But as mentioned by Cindy, I'm an attorney in private practice. I represent a whole bunch of FSBPT-like organizations, and they all serve their member boards by lessening burdens on state government and providing effective and efficiencies to the regulatory and licensure process, if you will. Most all of my clients develop, administer, score, and maintain a uniform licensure exam program. And probably one of the biggest issues that all of my clients address is this promotion of uniformity and the recognition of state-based licensure. And so that's my world. That's what I've worked in my 34 plus years of practice. And so let's get that picture off the stage or off the screen there. So as mentioned, this is January judgment. So that's what we will be covering, these couple of cases. We've kind of mapped out a few things in the future there, playing off of the alliteration of March, May, July, September, and November. So we invite you to put these on your calendars. I believe it's the third Wednesday of every other month. And so we hope to see you continue to come back, and hopefully my content will stimulate you to come back. So on to the cases now. There are two cases we'll talk about. As I mentioned, one is from 1982, Doe versus the Iowa State Board of Physical Therapy and Occupational Therapy, as it was called back in 1982. Excuse me. And then more recently is the Calcaterra case, which was just decided a couple of months ago by the both of these cases, by the way, are the Iowa Supreme Court. So short of going to the U.S. Supreme Court, which these won't, these cases have been decided, and this is the, if you will, law for Iowa. If anybody from Iowa is on the line and wants to chime in at any point in time to help clarify, give us some additional background or any other editorial comments, feel free to do that. And I certainly welcome that. And so onward, as we talk a little bit about setting the stage for these cases, let's just talk a little bit and set some foundation for the complaint process, because these cases are about a right to know, or perhaps more accurately stated, not know certain information. And so everybody on the line ought to understand how your complaint process works. Complaints roll in, they're probably assessed by staff, perhaps they're farmed out to a subcommittee. Lawyers perhaps become involved to ensure that the complaint is relevant to the role the board plays and the statutory authority granted to it. And so everybody has a little bit perhaps different process in mind, but in general, those complaints are going to be assessed. Some of these complaints may have no basis whatsoever. They may be outside the scope of authority of the board itself. They may feel that they're retaliatory or anything else. And so those initial assessments are going to be undertaken through a process that you all should have some working knowledge of. And so keep that in mind. Likely those should be in your policies and procedures that you should have as a board. But if not, that's okay. They are going to follow that process. So the next question I'll bring up is what do you do with an anonymous complaint? And while not relevant to this case itself, do you accept anonymous complaints? And relative to confidentiality, this may be a more interesting question. And so somebody type in the chat just yes or no. You either accept them or you don't. And if the answer is no, that just means that you don't even assess these complaints. They go immediately into the circular file, and perhaps they're no longer looked at, and there's no resources dedicated to any investigations whatsoever. So I'll just kind of keep talking. Yes, they're assessed. So some are chiming in here. Feel free to type that into the chat itself. For those of you who are thinking about this question or adopting policy related to it, I don't believe it's good policy to automatically throw away or not even consider anonymous complaints. I think that you should assess the severity of the allegations within the complaint, and then work with your lawyers to decide, is this something that we can investigate and perhaps then ultimately come to a conclusion or not? And if not, perhaps then it does get pushed aside. But I don't believe it's good policy to just merely say because they are anonymous, they would not be examined as well. And so we've talked a little bit already about the initial assessment. Is it within the scope of the board? Is it referred for investigation? These are all decisions that will be made, taking a lot of issues into consideration. One is the severity of the allegations. Two is the resources of the board itself and others. And so complaints may come in that aren't investigated for whatever reason. And then ultimately we get down to the bottom of the slide here and ask ourselves, well, when does the respondent find out about the complaint? Immediately? Is there some initial examination or investigations that are undertaken prior to noticing up that respondent? And you'll notice I'm using the word respondent, not licensee. And why is that? Anybody? Unmute, say the word out loud. Unlicensed practice, right? And so not everybody is necessarily a licensee. And the question then is, are unlicensed individuals subject to administrative procedures within your jurisdiction? That's a super important question, very important, especially in today's day and age of technology, and where individuals can practice across state and perhaps international lines without being licensed, and they may be violating your Practice Act. So what happens and what can you do or what can you not do? Now, some of you will react and say, well, we can refer it to the Attorney General's office for criminal prosecution. That's a true statement, probably in all jurisdictions and in all the professions I work with. However, will the criminal authorities actually prosecute unlicensed practice cases? It's a very interesting question. And perhaps these states' attorneys have so-called bigger fish to fry. And without severe consequences to unlicensed practice, like body bags or injury, it may be hard to get the attention of these criminal authorities. So quickly back up to bring closure to that issue is, hopefully your Practice Act provides you with administrative authority over all persons, not just applicants and licensees. So at what point in time is that respondent, now back to my original question, do you disclose to that respondent the fact that a complaint has come in? And then what is it that's disclosed? A summary of the complaint itself. Is the actual complaint attached to a cover letter, which may be a template letter sent out to that practitioner, that respondent, to then respond to? And so to help set the stage and the foundation for the cases we're going to talk about, I wanted to at least address a few of these issues. And I'll pause right now and ask if anybody wants to unmute and talk about any of the issues yet so far. Complaint process, anonymous complaints, initial assessments, or notice to the respondents. Does somebody want to unmute and tell us, when does the respondent in your jurisdiction hear about the complaint? Is it immediate? Or type it in the chat. This is your time to shine.
Ours is not immediate. It's only until initial investigation is done by the staff of the board.
Excellent. What jurisdiction?
Rhode Island.
Thank you. Excellent. And so Rhode Island wins the first trip of the year for 2022. Contact Rich or Jeff and they'll give you your free round trip tickets to, where are they going this year? To the Bahamas or something? And obviously I'm joking, so don't take that too seriously. So now the next issue that comes up is, well, what is subject to public disclosure? So at some point in time, maybe after the initial preliminary investigation, the respondent is notified as identified in Rhode Island. It may be right out of the chute in some jurisdictions, and it may be a little further down the road, wherever you are. But at one point in time, is the public able to get access to these complaints? And this will become the heart of the cases that we're going to talk about in a minute. But what is subject to public disclosure? Okay, and so you all ought to know the answer to this question. And in general, government operates in a transparent manner. So overall, generally the rule is everything is subject to public disclosure unless it's subjected to an exemption or exception of some sort identified in the law. So we can all at least start with the premise that perhaps issues are subject to public disclosure. So if I start asking your board for copies of complaints that have been filed in the last 5 years, will you give them to me or not? And if not, you are going to have to cite the law that says these are not subject to disclosure. So your lawyers are getting involved. This is something that you ought to at least have some working knowledge of to identify how and when you might disclose issues related to that. So again, if anybody wants to chat in or unmute and talk about what may or may not be subject to public disclosure, feel free to do that. Now, the first case I'm going to talk about, it's a 1982 case. It deals with whoops, I'm already mixing them up. The second case deals with declaratory orders. So let me backtrack a little bit here and quickly identify why I'm setting the stage for this. And so because that 2021 case out of Iowa before the Board of Medicine deals with what's called a declaratory order, I thought I'd at least identify what is a declaratory order. So do you all issue them, and why and when, and what is the process for issuing a declaratory order? So does anybody want to unmute and tell me what you believe a declaratory order is, and do you actually issue them in your jurisdictions? And it will be relevant in the case we're about to talk about. What's a declaratory order? Anybody? And maybe you don't know, and that's okay too. So the next slide here, and I had to steal this from the Board of Nursing in Iowa, and I don't mean to pick on Iowa, but because the cases came out of it, I'm trying to center my thoughts around how Iowa might treat these. I could not find on the medical board's website anything about declaratory orders, so I borrowed it from the nursing board and did not see very many issues related to declaratory orders on any of the websites I checked in the state of Iowa. But as you can see here, it's front and center in the nursing board's website. A declaratory order has the same status and binding effect as a final order issued in a contested case proceeding. And so in certain circumstances, a board may say, we're going to issue a declaratory order interpreting a statute. So we may issue a declaratory order that says dry needling is within the scope of practice, or perhaps is not within the scope of practice, wherever you all may land on that, based upon the statutory wording defining the scope of practice. And that order then will have the same status and binding effect as a final order in a contested case proceeding, meaning some may or may not be able to rely upon that. So keep reading there. It is binding on the petitioning Board of Nursing, the petitioner, and any interveners. So that starts to tell me it's very specific to a particular question that was asked or may be being asked by a petitioner or the board itself. And it's applicable only in circumstances where the relevant facts in the law involved are distinguishable from those on which the board order was based. And so here they're trying to, I think, rein in the broad scope of a declaratory order. I might suggest that I would interpret a declaratory order to be much broader. And I use my example already. Dry needling is within the scope of practice. That applies across the board to all persons who are practicing or wishing to practice, and telling them that perhaps they need to have that physical therapist license in order to lawfully engage in those activities. And then the last sentence there, the issuance of a declaratory order constitutes final agency action, meaning that at that point in time, it can be published and it can be made public, if you will. So we've identified, going back a slide quickly, a declaratory order. And the question is do you use this power, if you will, and should you use this power? And I must admit, I go back and forth when I'm asked this question as to whether it's good policy to issue declaratory orders or not, remembering that they are binding on the board itself, and they're binding on perhaps future decision-making by that board until such time as perhaps a new declaratory order is issued that might surface. Now, the other issue that will come up in these cases are press releases. So I'd ask the same question if anybody wants to unmute. Do you all use press releases? And if so, when do you use them and why? And what is the process for determining that? I think we all know what a press release is, but these are public statements that are made. And so, for example, I would ask you, if you issue an adverse action against a licensee for some wrongdoing and you suspend their license for 12 months, subject to reinstatement based upon a lot of factors, Do you issue a press release that tells the world, the public, that you took that action? Anybody? Yes or no? Feel free to type it into the chat. How does the public find out about final adverse actions? So I'm just using that as one example. You might issue a press release that says, congratulations to so-and-so who's been appointed by the governor to the board. We're happy to have him or her on board. You may issue press releases like that, or other press releases related to any other activities of the board itself. But if we're dealing with, say, a final adverse action, is that subject to a press release, and should it be? Or are there other circumstances where you might issue those? So in the state of Iowa, here is a November of 2021 press release issued by the Board of Medicine. Don't worry about trying to read it. But in the end there, it does say that a particular physician who is 63 years old was granted a permanent Iowa medical license subject to terms of a consent agreement on November 2nd of 2021. And it tells a little bit about what happened and the so-called sanctions that were imposed upon this person. So here is a press release that's posted on the website, and I don't know where else it may be sent, but this is a step by a board to overtly push out information rather than have people come to the board and seek information. Now, I will tell you, in preparing for today's remarks and going to some of the Iowa board websites, it's hard to find information. And I feel like I'm a relatively sophisticated consumer, and I have trouble finding certain actions or final actions or others. And so ask yourself that question too, is how accessible is information? Now here, this press release, I'm assuming, is pushed out in addition to being placed on the board's website. But the last couple sentences there, the prohibition, under the terms of the November 2, 2021, the board issued a citation and warning prohibiting this physician from prescribing and administering controlled substances. There's a limitation to that prohibition. And then the very last sentence, the practice restriction shall continue indefinitely. Anytime I see an indefinitely, makes me ask questions about due process and how does this person know when the end is near insofar as lifting these particular sanctions, but that's a topic for another day. And so do you all use press releases? Should you? And is this an example of how you might use those particular press releases themselves? So now on to the first case. Let's start with the 1982 case. And I want to give you a little bit of facts about this case, because in the end here, you can see you're a physical therapist who was the subject of a complaint that was dismissed. Okay, it was investigated according to the court and then dismissed. Was this physical therapist entitled to disclosure of the complainant, the person who actually filed the complaint? And the answer is no. And the answer is no. There's a citation to a statute there on the bottom of this particular slide. And that statute is also subject to the 2021 case. The numbers have changed a bit, but excuse me. So let's talk about the facts a little bit here. First off, the question that the court said they're looking at is the confidentiality of the identity of persons who make licensing misconduct complaints. Okay, so we're step back and say, well, gee, is that subject to public disclosure, or to whom and when? Is it subject to disclosure to the accused, to the respondent, the licensee in this case? Is it subject to disclosure to the media if they ask for it, or anybody else? Now, in this 1982 case, what I find kind of somehow ironic is that the petitioner uses a pseudonym, Jane Doe, to protect her own identity while she's seeking the right to identify the complainant. So now, gee, I would have thought that the identity of licensees is probably not subject to much confidentiality, and the public has a right to know who is duly licensed and the status of that license. But the board, as I mentioned here, investigated this complaint and ultimately decided it was without merit, dismissed it. Now, how did the board get this complaint? According to the court, and I was not able to find any more details on this, but it says here the board received the complaint at a regular board meeting. Now, a regular board meeting to me is open to the public. And so I'm not sure how this complaint was actually then filed at a regular board meeting and then was not subject to disclosure of who the complaining party was. Although the opinion here does not identify that the complainant specifically was involved, but what the court does here say the complainant informed the board of a suspicion that Jane Doe, our now unidentified licensee, was engaged in illegal drug traffic. Okay, so what happened was the board turned the information over to the criminal authorities. The criminal authorities did some investigation. They interviewed the actual licensee, found no merit to the complaint about illegal drug trafficking, reported back to the board, and then the board then dismissed the complaint out. Now, the practitioner obviously knew this complaint was filed because the criminal authorities showed up and interviewed her, but did not know who the complainant was. And the practitioner then said, I want to know who the complainant is. Now, the statute at stake here says the following. There's a lot of words on these screens. I tried to highlight it, but it basically says all complaint files and investigation files, and all other investigation reports and other investigative information in the possession of a licensing board, which relates to licensee discipline, shall be privileged and confidential and not subject to disclosure, discovery, or use in any other proceedings, is what it goes on to say there. So let's take a step back now, and I read a lot of statutes, and I am quite I'm candid with how language is used, and so let's look at this the second part of the highlight, which relates to licensee discipline. So does that tell me that if it's an unlicensed person who has a complaint filed against, that this statute doesn't apply? And now are we dealing with another interpretation? I think the answer is probably no. The intent of the legislature was not that. However, we have to choose our words carefully. And here they said, which relates to licensee discipline. So if we have an unlicensed disciplinary action administratively, we're going to ask ourselves that question. So the bottom sentence there says, however, a final written decision and finding of fact, including a decision referred to, etc., shall be a public record. So what that's telling us is that once the board is finished with the matter, then it does become public. And the whole proceeding issue, if you will, or the final adverse action would be a public record. And what's in that final adverse action? Well, we can all step back and ask ourselves what may or may not be in that. So in this particular case, the practitioner, the licensee, said, I want to know who it is. And the board said that they will release the information to the candidate. And it went ultimately up to the court itself, and ultimately the Supreme Court, which said, no, it's not subject to disclosure. Okay, so that's the bottom line of it. And as the court said, it's obvious from the context of the language you see there and the stated purpose that the disclosure exception applies only when a disciplinary proceeding has been initiated. So the bottom line here on this court arriving at its decision is that if there is no initiation of discipline, then there's going to be no disclosure to this particular practitioner of the identity of that particular complainant itself. And it's a relatively, I think, probably easy decision to come to by the Supreme Court of Iowa back in 1982, and it's probably consistent with the intent to protect practitioners and otherwise and complainants in the event that there are these kinds of requests for disclosures. So if we move on now to the 2021 case, which is going to address somewhat of a similar issue and the similar language you're about to see. But here the court, and again, this is back to the Supreme Court of Iowa, they're asked to review an Ohio Board of Medicine declaratory order. So this goes back to our declaratory order question. What is it? When do you use it? What does it mean? And they were interpreting section of the statutes that we've already identified. There's a little bit of changes to it, but not much. They were interpreting that statute, and the board concluded that the statute allows the Board of Medicine to publish statements of charges and press releases containing investigative information. So meaning that when a complaint rolls through the door and there's all sorts of allegations, in spite of the fact they have not yet been proven, they can be published in a press release and or placed on the website, or perhaps both of those that might have happened. So in this particular 2021 case, there's a history behind this, because in March of 2013, charges were filed against a physician accusing him of a pattern of disruptive behavior and unethical and unprofessional conduct. So this goes back to 2013, okay? At the same time those charges were made, the board sent out a press release identifying all those charges and allegations on both a press release and on their website, okay? So according to the Supreme Court opinion here of November of 2021, virtually all licensing boards in Iowa follow the same practice. So they are able to post through press releases or on websites or both allegations of wrongdoing prior to the ultimate disposition of the matter, okay? So back to this case now, 2013 charges filed, published on the website and in a press release. About a year later, in April of 2014, the matter was resolved through a settlement agreement, okay? So the board posted the settlement on its website, which is probably ordinary course for most all of you, and not only disclosed the settlement, but reiterated the factual allegations, even though those allegations were not admitted in the settlement agreement. So we could run an entire seminar on how to draft a settlement agreement, what should and shouldn't be in there, and other admissions of wrongdoing versus not. And there's debate back and forth between lawyers and otherwise. So an important concept, though, for us to consider is what are in those settlement orders. And by the way, I always suggest settlement orders say that certain things will be published and they're identified. So that should be one of the elements of the order itself. So case is now settled in 2014, and according to the Supreme Court, the Iowa Supreme Court, several years later, information about the allegations against this physician were still on the website. And so the question is the next question you all should consider is, when do you take things off your website, if ever? And this is a settlement agreement versus a contested hearing. Does that make a difference? And so you all have to start identifying a lot of these issues about publication, outreach, and perhaps confidentiality and sensitivity to the licensees and the complainants themselves. The physician here filed a petition for a declaratory order, back to that declaratory order question, with the board saying, can you now answer the following question? Does the law, and it cites the law, prohibit the board from publicly issuing or publishing statements of charges and issuing or publishing press releases which contain investigative information? So now it's a very similar question to that 1982 case, but it deals with allegations rather than the identity of the complainant itself, him or herself. So the board declined to answer that question until the court stepped in, because now litigation was eventually filed, and the court said to the board, you have to answer this question. Does the statute prohibit publishing statements of charges in press releases and or on your website? And of course, as you can predict, the board said it does not prohibit it. So we can, as a board, publish it. And now the litigation turned to the attention of, is that the appropriate interpretation of the statute itself? Now here's the statute again. You've seen most of this language, all complaint files, investigation files, other investigation reports, and other investigative information in the possession of a licensing board, which relates to licensee discipline are privileged and confidential and not subject to discovery, subpoena, or other means of legal compulsion for the release to a person other than the licensee and the boards. I'm right back to only the licensees. What about an unlicensed person? How might we interpret that? Topic for a different day. So the court eventually now is addressing the issue of statutory interpretation. And I'll go back to the case here itself. And you can see the Supreme Court ultimately held that investigative information regarding a physician could not be released to the public in a statement of charges or press release when there was no underlying final decision. So that gets back to the last sentence of these of both of these slides dealing with the statutes. A final written decision and a finding of fact of the licensing board in a disciplinary proceeding is a public record. So that's when it triggers the availability to actually publish and outreach. And I think we can all probably at least identify one of the issues is to protect the licensees during the process. And if you have frivolous complaints or others that are being filed and they're being published, does that disadvantage a licensee? Well, perhaps we could argue that. I myself like to err on the side of disclosure, but I can certainly see the other side of the arguments here. Now, so the question here is one of the issues here now is do we define complaint files, investigation reports, and other investigative information? I couldn't find definitions that place some parameters around this, but I suppose it's anything to do with the complaint itself and the investigation and the ultimate facts that are established or attempting to be established. But we may get into a debate over what falls within the restrictions versus what is outside of those restrictions. But the court in the 2021 case here ultimately said that when dealing with the question of deference, and let's just step back and decide what is deference. And deference is when courts defer to the boards because they're the experts to say, hey, you are made up of practitioners, licensees, and public members, and you bring expertise to the table that adds efficiency to the process. So should there be deference here? And the court said no, because the special expertise of the board is not necessary to resolve this question related to the disclosure of facts and or allegations related to the complaints itself. Here the court, I think, pretty quickly and relatively easily decided that this information could not be released under the statutory language. And if anyone disagrees with that, it's up to the legislature to change that language. And so, and I do see a comment here, Iowa, we have interpreted the statute to mean that complaints of unlicensed practice are not protected by this confidentiality provision. So there's at least begin with an example of the question I've asked a few times about non-licensees and how that may be treated. So investigative information, what is it? It's probably just about anything that is discovered as part of the investigation related to a complaint that is filed with the board itself. We've talked about anonymous versus signed and otherwise, and we've talked enough perhaps about unlicensed practice. But if it falls within that now investigative file itself, perhaps it cannot be disclosed until still such time as the matter is over and is resolved. If it's resolved via a contested hearing, you've created a record. That contested hearing is likely open to the public, and the final adverse action will be written accordingly. If it's resolved through a settlement agreement or some other means prior to a contested hearing, then we're going to ask ourselves, what is subject to disclosure? And here is where the drafting of those settlement agreements is extremely important. And disclosure should be addressed within the agreement itself, as I've mentioned. And so now we step back and reflect upon, what is it we just talked about now? One of the arguments, by the way, made in Iowa over disclosing these allegations prior to the final outcome is that, hey, all the boards are doing it. It's in the rules and regulations. It's part of the past practice and otherwise. And the court pretty quickly put a stop to that and said, if the statute doesn't allow it, you cannot promulgate a rule or a regulation that is inconsistent with the statute and the intent itself. And so as courts are asked to look at statutory language, they will look at the language itself and the plain meaning. And if need be, they look at the history, the legislative history, and try to figure out the intent of the legislature. And here, I think the court found the language to be not ambiguous and able to be interpreted in a manner that allowed the court to come to an answer. But as I've mentioned before, if it's ambiguous enough, the statute perhaps needs to be changed. And this is the whole balance of power between legislature and judicial branches of government. And so now back to the question, what does all this mean? Well, first off is we're going to look to the statutes to begin with. Okay. And what do those statutes say? And remember, for those on the line today, that the statutes go beyond just your practice acts. There may be an Administrative Procedures Act or other laws that apply to your boards in addition to the practice acts itself, which is specific to physical therapy. So you're going to get advice on this, seek legal advice where you need it. And as a quick reminder, what I'm providing to you is some information, not legal advice. So make sure you ask your lawyers and get answers to the questions that you may have. So statutory interpretation. The next issue is rules and regulations. And as I've already identified, the statute gives you the authority to promulgate rules, and those rules have to be consistent with the authority granted to you in that practice act, the statute itself. So you cannot expand certain scopes, or you cannot grant yourself authority to do things that the statute don't recognize. And so everybody knows that that's fundamental. However, the whole past practice and the rules and regulations did not fly before the Iowa Supreme Court because it was inconsistent with the statutes themselves. As mentioned, all boards are doing this. And I think in Iowa, there was a lot of boards that probably were disclosing the kind of information that is now being prohibited from disclosure until the end, if you will. And so I suspect that this recent 2021 opinion probably caused most of the boards in Iowa to change their process related to disclosure to the public, both press releases and or website publications about the complaints themselves. And we'll wrap up these bottom 4 points with issues related to fairness and due process. And so at what point in time, excuse me, at what point in time might we argue that due process is being violated by disclosing allegations on the website or via a press release prior to them actually being either established in the end or at least preliminarily established through some investigations prior to disclosure. And I would suggest to you that there are some jurisdictions in the US, as soon as a complaint rolls through the door, it's sent on to the respondent immediately with a copy of the complaint attached, which discloses everything, not only allegations, but the complaining party, him or herself. And so how you handle this in your jurisdictions, you're going to have to be thinking about that. But there are legal issues related to this, fairness and due process. What are the rights of the licensees or other respondents related to non-disclosure versus disclosure? And we could have a sophisticated legal argument about this, but it is a matter that's worth considering. What are the rights of complainants themselves? Okay, can they be held in confidence or disclosed? And if so, disclosed to the respondent or disclosed to the public or disclosed to the media or anybody else? And then lastly, of course, we cannot forget about the rights of the public itself to have a system that not only is fair, but it is protective. It's carrying out the intent of the legislation to provide that important public protection that exists. So far, do we have any comments about, I've said a lot here so far today, any comments or questions that might surface about some of the issues that I've talked about. So we have complaint process, preliminary investigation, notice to the respondent. We have investigative files that are developed and disclosures at what point in time. Anybody have any comments or questions that you want to raise about your jurisdictions related to any of these topics?
This is Laura. I'm from Iowa. I have a couple comments if it's okay to chime in on this case.
Absolutely.
So this case, and I just wanted to clarify a couple things in terms of when the information was published back for Dr. Calcaterra. The boards do receive complaints and they do full investigations, and all of that remains confidential. If the board wants to do discipline at that point, typically they try to work with the licensee to see if they can resolve it via some kind of settlement agreement. And if they cannot, and the board still wants to proceed with discipline, at that point is when they issue those charging documents that became the subject of this case. And those charging documents, it's probably 1%, 1 to 5% of cases that ever get to that point. There's a separate statute that says that those notice of hearing and statement of charges documents are public, and that they have to include the laws and rules that are alleged to be violated, and have to include a short, plain statement of the facts. And so that's why that quote unquote complaint information is included. It's supposed to be a sort of a brief summary to put the licensee and the public on notice as to what the board intends to move forward with. So obviously, since this case came down, what we've done in Iowa is we still are issuing that public charging document, but we are redacting the actual factual circumstances. So it's still out there that there's something pending, but it's not, the facts themselves are going to be redacted until the conclusion of the case. The other thing I'll just add is I think the Iowa Supreme Court has a lot more familiarity with the attorney disciplinary process, which has for years operated much differently than these licensing boards. So I think that process is a lot more confidential until the very end. And I think that probably played a role in their decision because it just seemed different to them that a sort of a charging document would be public. And I don't know that they gave enough consideration to sort of the other statute that requires this information to be in the public notice. So it's been an interesting time here the last couple of months trying to redo or rethink how these things work. And there's actually a lot more litigation pending right now from multiple John Does relating to disciplinary processes in Iowa. So probably some more cases for you in the future to talk about.
Well, I appreciate your comments and your candor and the clarifications as well. And so related to and you don't have to answer this, I'll just ask this question to the ether and everybody, but if things are changed like this, do the boards go back and then clean up their websites from information that has been on there for years? And if it never ripened into that charge, if you will, the formal charge that was mentioned, Laura, was that your name, Laura, right?
Yeah, Laura.
Yes. So is that what happened in Iowa too?
So on the websites, all that's posted is public discipline that's basically been finalized. And so we don't believe that decision changes any of those documents because it does say the final outcome is public. So those are all final. We did have a small number of charges that were sort of pending. Maybe hearing was scheduled, sometime for this year. And in those cases, we just we went back and redacted the facts on those. But it was a small number. So all of our public discipline is posted on board websites, and it's sort of indefinite. I mean, it's out there. It doesn't go away after a certain period of time, which is much to the dismay of licensees, I think. But it's all posted, and the facts are posted because those are all final outcomes.
Got it. And I agree with that, by the way. I think they should be on the websites in perpetuity, because it's an accurate reflection of what happened, even if it happened 5 years ago. So, and as mentioned, and to clarify too, and Laura, if I get this wrong, correct me. What's being posted now is post decision making, post final adverse action. So obviously the public does have a right to know then. It's the pre-final action as to how this might occur, and from a process standpoint. And I've always grappled with the question of If I call your board and say, is Dale's license in good standing? And the answer is yes. And then I'm a sophisticated consumer and say, is Dale subject to any complaints? You know, at what point in time might you disclose, well, yeah, there's a pending complaint against Dale. Well, gee, what's that complaint about? Well, we can't tell you. Or, you know, how that discussion might go. And boards have to be very sophisticated in how they're going to decide how to answer those questions if they come in. And by the way, they should come in, because it tells me we have a sophisticated consuming population that is interested in the status of the licensee that they're seeking service from. And so, you know, good standing, outstanding complaints, any previous disciplinary actions. I usually ask this question that I'm phrasing now in the sense of these private final orders, which some states engage in. And so if I'm a sophisticated consumer, I might say, license of good standing, yes. Are there any private final orders that, you know, that are issued against this practitioner? And if the board says, you know, we're not sure what to say to that, it's kind of a similar question here. Because if I start to ask about allegations, I'm assuming they won't be disclosed under this precedent now, but these are interesting questions. So thank you, Laura. Others that want to chime in about how it works in your jurisdictions and how this ruling may or may not be the same, you know, what would the outcome be in your jurisdictions?
I had a question for Laura, just to continue the comment about unlicensed practice. So your interpretation of the statute, has there been a press release or a declaratory order, or have you had issues with unlicensed practice come up related to the confidentiality issue?
No, you know, we don't really get many complaints of unlicensed practice. Particularly, I work with several boards for physical and occupational therapy. We really haven't had any. We've just with boards that do get those complaints, that when the board discusses them, they discuss them in open session as opposed to closed session. And the reason being that we don't feel that there's a ground, we have to have a specific grounds to go into closed, and without that confidentiality provision, we've just said that those need to be in open. The boards in general just don't have a lot of administrative authority over unlicensed practice. So if there does need to be any action, it's typically needs to be referred for either civil enforcement through the AG's office or criminal enforcement.
And so you say doesn't really have jurisdiction. Can you as a board administratively sanction someone who does not have a license?
No, not for physical
Okay.
therapy.
Okay,
No.
got it. And many jurisdictions are that way. That's not unusual. It's something that I suggest that be changed, but you know, how far can we take that? And that's why you have model practice acts and others that help provide guidance to these types of questions. And so, but that's a great point. That's a great question as to how you handle it on the unlicensed side as well. Other questions or comments about how this may play out in your jurisdiction? Or you can keep Laura on the spot too. And one of the reasons that this is an important issue in my mind is the media. The media may ask your board under open records for copies of complaints for the last 5 years. And do you turn them over or not? And if so, do you redact some? If you turn them over, do you redact things out? And you know, I could predict, Laura, that there may be struggles as to what you disclose pre-final adverse action when you're redacting facts versus allegations of unprofessional conduct. Is, you know, can you use a phrase like that, or boundary violations or something else where you are giving away the basis for the charges themselves? And so I would suggest that maybe a struggle to figure out what language to use, and you'd need some advice about that. But so, other questions or comments? I know you guys are out there. I can hear you. In these last couple of minutes, I will reiterate my thanks to FSBPT and the board and staff, and the big giant thank you to each and every one of you for what you do as public protectors and enforcers of important statutes and regulations across the country and across the professions. And so you're not thanked enough. I will provide that added bit of thanks as well. And if there are no other comments anybody wants to make now, Cindy, I'll turn it back to you. But quick, any other comments that anybody wants to make regarding any topic related to what we just talked about?
Dale, thank you so much for that great presentation. We always get so much out of each of the cases that you presented. Just raises so many more questions that we may not have thought about in our day-to-day and how it applies to our state. So I think that that is great for us to think a little bit deeper and look at how we handle things so that we do provide the best in public protection. So thank you again for your presentation. I just want to remind everybody that following this webinar, we will have a half an hour of CBA Shop Talk. So I hope that everyone can stay on. We can have open discussion on any topic of your choosing, and it can be a pretty lively session. So hopefully you can hang around for that. Thanks again, Dale.